Hello everyone, and welcome to today's video. Eric Martin has returned to jail after allegedly beating his sister once more. He has informed the courts that they no longer have authority over him, but now he takes a different approach and dismisses his own case.
And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
Let's get started because this is going to be a terrific one.
Okay, now we're on Eric Martin. This is 251756, the people versus Eric Martin.
Good morning, Your Honor. James Gizicki on behalf of Mr. Martin. Your Honor, he's waiving his right to a trial by jury, requesting trial by this court. And also, can I address bond, Your Honor?
Yeah, I've signed the order granting discovery. Mr. Martin, you understand that you have a constitutional right to a trial by jury?
I comprehend that.
Do you understand that, sir?
I comprehend it. I just want to add, as I told him, I really don't consent to no jurisdiction of this court, but since I'm being forced to make a choice, I'm saying an Article 3 judge is going to be the choice, the forced choice. Article 3 judge.
Okay.
Even though the case shouldn't go there, let me mention this too now. The case shouldn't go that far. We shouldn't even be wasting taxpayers' money, nor my time in here. First of all, I proved my sister lying before on me with the same type of charge, okay? I don't know the case number right now. I asked Jasinski to find out what it is. But in the same court, 23rd District Court, the judge is seeing she lied when I questioned her, did you swing at me before I kicked you? She answered no to that, and it was seen on the camera she lied. This is especially why I should not be made to wait on this.
Mr. Martin, you have a constitutional right to a trial by jury. Are you voluntarily waiving the right to a trial by jury?
Since I'm being forced to make
well, you're not being forced to make any choices.
Well,
you can have a trial by
so I am being
Mr.
forced.
Mr. Martin, listen, we can get through this, or we can go back and forth, and then I end up muting you, and then that's how we go forward. So let's see if we can do this without that, okay? You have a constitutional right to a trial by jury on this case. Are you waiving your right to a jury trial?
Yes.
It's a horrible move, since a trial by judge is much more difficult to win, particularly when your entire argument is predicated on delusions and pseudological theories. Eric Martin and his group of merry shortbusters would have realized by now that their best chance of confusing the justice system's adjudicators is to have them serve as a jury of your peers rather than a judge.
And you understand that I'm the judge of the court, that I will be the trier of fact on your case?
Well, I want a motion for a judge trial, but I'm going to object to you being the judge based on past constitutional violations.
Okay, well, your motion for recusal is denied. So now, Mr. Martin, are you electing for me to try the case, yes or no?
In that forced sense, yes.
Well, you have two choices, a jury trial or me. Out of those two choices, which one do you like?
Are you an Article 3 judge?
Mr. Martin, I'm not going to entertain jurisdictional arguments. I'm asking you, do you want a trial by a judge or a jury? And I'm being very patient.
By a judge, I already said Article 3 judge. Article 3 judge.
Okay, well, I will be your judge. I've made that clear. This is a case I have jurisdiction over. It's a misdemeanor that's alleged to have occurred in the city of Taylor. So you're indicating to me that you're relinquishing your rights to a trial by a jury, and you'll be tried by me. And you understand, you've had a chance to talk to your lawyer about this, Mr. Martin?
Yep.
Okay.
I also want to make it clear, some other things to say. I enforce my right to a Republican form of government under Article 4, Section 4 of the U.S. Constitution, which is why the court don't have jurisdiction over me. And I am the third party beneficiary here. I am not the defendant.
Amy, can you find
Despite
me
the fraudulent presumption otherwise.
possible?
Since your parents have been calling you Eric Martin long before they dropped you on the first step, I suppose we may accuse them of fraud in the jury trial.
All right, give us a second, Mr. Martin. I'm trying to get your jury trial date. We can even on a same day.
I want to make clear, I'll point out, it's supposed to be 28 days, and Saturdays and Sundays are not supposed to be excluded. Because the 28 days is specific for speedy trials and misdemeanors. And since that's specific, under the core rules, it should be 28 days without excluding Saturdays and Sundays or the legal holidays. That's made clear, I want to say, under the rule that dictates speedy trial, MCR 6.004C, and also MCR 1.103, the applicability rules, that clearly says, where a rule is specific, it applies to that. So that the specific rules control over general rules.
Okay, Madam Prosecutor, how many witnesses?
I would say maximum.
Okay, Mr. Gazicki, how many witnesses?
Your Honor, first of all, I just want to put on the record that Mr. Martin in the past has not wanted my representation of him. Today he says it's okay for me to represent him. I just wanted that on the record. I also advise Mr. Martin that his arguments that he makes about sovereign citizens and that is something that I can't follow, nor can I ask the court to follow it. Just so that's on the record. As far as witnesses goes right now, Your Honor, would say one.
Okay.
Can we approve?
I mean, Mr. Gazicki's in the other room. Mr. Gazicki, can you come on in? We'll meet you in the back hallway. All right, Mr. Martin, 1 second.
Yeah, and I got something to say too while we get time in response to what he said.
I'll venture to estimate if you are dismissed. Would you protest that you are not a sovereign citizen, but that you are among the sovereign people? Or will you protest that you are not the legal corporate fiction, Eric Martin, but the circus clown who is frequently imprisoned and widely ridiculed? The public defender now enters the courtroom, and Eric Martin does something different this time by dismissing his own case. At this moment, the judge leaves.
And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
Eric, that's not how it operates, but it's a bench trial. It's amusing to know that there is a halfman out there who genuinely thinks this.
All right, we're going to set a bench trial July 14th in person at the 23rd District Court. July 14th at 10 a.m.
Your Honor, can we address bond?
You can address bond.
Okay, Mr. Martin requested that I ask this court if he can have a no condition type bond in this matter.
Okay, here's the problem. I'm just going to say it on the record. Request for a bond modification is denied. Mr. Martin had a very simple bond condition that he not go back to the residence. I know he doesn't think I can tell him that, but he's wrong. And he went back to the residence and got arrested again, allegedly, for being at the home when there was a no contact provision in place. He clearly has a history of non-compliance. He doesn't think the court has jurisdiction over him. And the only way I can assure his presence and assure the safety of the community is to keep Mr. Martin in custody because he will not comply with my bond conditions. There's no such thing as an unconditional bond. Okay, bond denied. And Mr. Martin, if you want to file motions that Mr. Gazicki legally could not file in good faith, feel free to file them. He's governed by court rules. He cannot file frivolous motions. So if you want to file more motions, feel free, get it, go at it. But Mr. Gazicki has indicated for the record, he will only be filing appropriate motions with this court. We'll see everyone back on the jury trial. That's my first date.
I have
July.
motions to make right now. I have some motions before we leave. I have
Okay.
some motions. Okay, and that is okay. Well, first, objection to what you just said, your statement about, there's no such thing as an unconditional bond. Yes, it's my right to be presumed innocent under the due process. The due process right be presumed innocent before guilty. Because I am presumed innocent, that is why any bond conditions violate that right.
No, that's not right. The part where he claimed that any bond conditions violated his right to be presumed innocent until proven guilty. In fact, the U.S. Constitution's ETH Amendment expressly declares that excessive bail is a violation of your rights was more important than the motion denied section where you were innocent until proven guilty. There are some bail and bond conditions that don't violate your constitutional rights because there is a distinction between excessive and non-excessive bail. I'm sorry, Eric, but granting you a high bond after you willfully broke the terms of your PR bond does not violate your rights.
So
Okay,
violates
motion
that.
denied. What's your next one?
Okay, and I motion to dismiss because there is no probable cause. It is her word against mine. She's lying. She's been caught lying before, and there is no evidence at all. We have no case. There's no evidence, and that is not probable cause, as the U.S. Supreme Court said in Beck versus
Well,
Ohio.
for misdemeanor, so we're not having a preliminary exam, we're having a bench trial. And the prosecutor will have to prove the allegations beyond a reasonable doubt. And at
Right.
that time, Mr. Martin, if at trial date, I assure you this, if you pick a bench trial. I was a practicing attorney for years. I promise you this, if she cannot prove her case beyond a reasonable doubt, the case will be dismissed.
Right here, okay, but anyways, let me finish talking. I ain't finished talking about the motion to dismiss.
I know, but Mr. Martin,
As of right now,
what's your last motion? Do you have one more?
you haven't let me
hold on,
finish. If I let me finish the motion just based on no probable cause.
Okay,
As the
denied.
U.S. Supreme Court said in Beck versus Ohio, or it was Ohio versus Beck, I forget which word is first, but the probable cause is defined as fact sufficient for the belief. Her word against mine. I told the cop she lied on me. Okay, her word against me. Somebody have her word against mine. That's all there is. So that's not fact sufficient for the belief.
Mr. Martin,
There's no
I'm
probable
going by
cause
the
now.
jury
The
instructions.
case should be. Come on, let me
Okay,
finish.
denied. All
The
right,
case should
Mr.
be
Martin,
dismissed
we're
now.
Well, it sucks for you, Eric, because it's not going to be dismissed, and you aren't getting out of jail, alright? So that's the end of the video. I just wanted to give you a quick midweek update on our favorite software, Eric Martin. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm